director of Green Days by the River and a graduate of UWI St. Augustine Film Program. So check us out.
Hi, good morning, everyone, and welcome to our series of filming TNT, hosted by the UWI.Film program. This is our fourth and final session with this particular series, and it's been going pretty well and interesting so far. We're interested in conversations, events, workshops, seminars that have everything to do with developing our skills as filmmakers, networking, and all these other interesting, projects that we are up to. So in this particular session, it is session 4. It's called Lights, Camera, Contracts. We're looking into this idea of intellectual property, entertainment law, and protecting our rights as filmmakers and creators within our lovely industry within Trinidad and Tobago. And today, the lecture is being hosted by Dr. Justin Koo and Dr. Emma Perot. And it's going to be a very interesting session. And we are streaming live onto Facebook and YouTube, so we're going to keep sharing those links. So please tell your friends and encourage everyone to come. We really hope that this session is lively and informative. And while it may be our last session for this academic year, when we start again in the next academic year for 2023, we're going to have even more events and workshops and seminars. So please stay tuned, subscribe to our pages, follow us on social media and Instagram, and please keep up with our events. And as usual, all of our events are free and open to the public. Okay, so without further ado, we have Dr. Justin Koo and Dr. Emma Perot.
Great, thank you very much, and thanks for having us. We're always very happy to talk about intellectual property law, whether it's in the film industry, sports industry, or any other, party promoter and industry, etc. One of my main goals as an educator is really to bring awareness about intellectual property rights and to make, the situation a lot more palpable for people. It's the case that a lot of people feel intimidated by intellectual property law. So I'm here today to talk a lot about film and copyright specifically, but what we're talking about today is also applicable across the board. These things relate to you once you're creative. You don't have to be in the film industry to have to consider these things. Even if you're just making artworks at home, whether it's graphic arts, fine arts, whether you're making music, you're making movies, you're making short films, you're just TikToking or Instagramming, these things are relevant for you. So today we're going to talk about 4 key things. So we're talking about copyright. I'm going to give you a quick primer on copyright. So again, part of the presentation today is really to break down into very small bits and make it very easy to understand what is copyright law and how does copyright law relate to you. We'll then talk a little bit about due diligence. So as creatives, what are the steps you want to take to understand not just what you have, but how to make the most out of it, how to use it effectively, how to commercialize it. And I know it's not always about the money, but ultimately, if we're in the creative field, if we're in film, you still have to pay rent, you still have to buy food. So if you're being a creative, you still have to make money at the end of the day. So we'll talk a little bit about due diligence and how it is to make the most of as to what you have. We then get to the big topic, contracts. So this is where most people fall apart. This is where most people switch off. But it's arguably the most important element of intellectual property rights. You can have all the intellectual property in the world, but if you don't necessarily know what you have and you don't know how to contract for it, you're going to end up in a bad situation. And we have tons and tons of horror stories in the context of Trinidad and Tobago, in the context of the Caribbean, where creatives have lost out on valuable opportunities just by virtue of not actually contracting or entering into what we call a bad bargain and not understanding the value of the rights that they have. And then we'll wrap up with a discussion as to how to actually negotiate these deals. What are the things we want to be mindful of in doing the deal? what are the steps in doing a deal, and how do we get it all packaged together. Yeah? So let's start the discussion with what's copyright. So when we think about copyright, copyright relates traditionally to literary, dramatic, musical, and artistic works. There's also an additional element called neighboring rights. So when we talk about neighboring rights, we're talking about, in some jurisdictions, that's where film comes into play, or what is also known as an audiovisual work. There's also the context of sound recordings. And of course, for film purposes, you're going to have actual audiovisual works. You're going to have the large film at hand. You're also going to have music involved in that. But film is way more than just those elements of copyright. So when we talk about these copyright works, a film project is going to have all of these key elements involved. LDMA works, right? So you might hear us refer to LDMA works repeatedly throughout this presentation. So think about literary works and your film. You have a script, you have a screenplay. Those are written words. That forms part of the underlying film, and that is one protectable work. So when we talk about film and we talk about copyright, you need to understand that it's not just the one copyright work that you have. You actually have a multiple number of copyright works that are at play in this film. You then have dramatic works. So dramatic works is the actual repeated performance of that. So yes, you're recording the film, but ultimately there was a performance on the stage, on the set, and that constitutes a dramatic work. In your film, there might be a particularly well-choreographed scene. So when we think about musicals in particular, they're dance scenes. When you think about Bollywood films, they're dance scenes. The choreography involved in that is in itself a copyright work, separate and apart from the film. So that's two copyright works that we have at play now. Then you have the musical works. You have a score for your films. You've paid someone or you've organized with someone to make the music for your film. So the written musical notation, that's a musical work. If there are lyrics to a song that is included in the film, that's a literary work. So now we have musical works coming into play. Then you may have artistic works. You might have created a particular set. You might have a particular design in the background of your film. It may not necessarily, let's say, be a feature film movie. It might just be, let's say, a TV series or one of those talk shows or something like that. And in the background, there may be a mural. There might be artistic backdrop, that sort of thing. That's an artistic work. And when we put all of this together, when we actually record it, that's the audiovisual work. So when we think about ourselves as creators or creatives and more specifically as filmmakers, you have tons of copyright. The question is, do you know what copyright you have? So the first thing that this really is aimed at is to sort of train our minds to understand that when you have film, it's not just one piece of copyright you're working with. There are multiple pieces of copyright that we're working with. And additional to that, there's what we call the neighboring rights or related rights. These are sound recordings in the context of Trinidad and Tobago particularly. So separate and apart from the musical work, that is the musical notation, and the lyrics that are the song, the actual things that are being, the words that are being sung or said, there's a sound recording. That's where you actually put the music and the words together, you sing it, and you record it. So back in the day, it would have been on vinyl. Now it's all digital, so you're recording to an MP3 file, etc. That's the song recording. So that's an additional layer that you have to be considerate of. You are all filmmakers, so we are all in this industry together, and we have to think about not just the persons who are behind the camera, who's making the film, who's recording the footage. You also need to be mindful as to the persons who are performing. Those are the actors or actresses, and they have what we call performance rights. So their actual performance on stage that is being recorded as part of the film or the audiovisual work, that in itself constitutes something that's protected under copyright law, and again, under related rights or neighboring rights. So when you think about it in that way, it's not just the persons involved in the making of the film in the terms of recording it that have rights. It's the people who are contributing to the film. Everyone has rights, and all of these rights play together, and you need to understand how they intersect. You need to understand what you need to get permission to use. You need to understand how to contract for each of these individually. So some of the things that we need to be mindful of in terms of whether you have copyright or not, so noting that those are the things that are protectable under copyright law, there are three key things I want to talk to you about at this point. And these are three things that you need to be really mindful of as a potential owner or author of a copyright work. So authorship and ownership are two separate things. The author is the person who's created the work. That's the person who's expended the intellectual, creative elements that lead to the development of the actual work. So you only get protection for copyright if you have made an original contribution. What does that mean? It's nothing, it doesn't have to be new, it doesn't have to be novel, it doesn't have to be something that's invented. All it means is that you've expended the intellectual labor to create this new work and you did not copy it from any other third party. So if you just take your film and copy it from someone else, that's not going to give you copyright. In actual fact, you're going to be a copyright infringer and you're probably going to get sued for it. And we'll talk a little bit more about that when we get on into the commercialization elements. So you need to have an original work, right? So the original work must be one of the types of subject matter we would have just discussed. It must be an original contribution, meaning not copied from any other source and involves some sort of creative element. The threshold is very low. It's not like patent law where you need to have novelty, you need to invent something new. It doesn't have to be like that. So we can actually have multiple films about the exact same topic. As long as we didn't copy the actual film or the actual script, we're going to be perfectly okay, and we get copyright in each of our own works separately and apart from one another. What we need to know is that how long our copyright lasts. And this is now where the commercialization element comes into play. If we understand that we have a copyright work, we then need to start planning about how are we going to actually commercialize our copyright work. What are we going to do with it? In what steps? Do we have a plan A? Do we have a plan B? Do we have a plan C? And as part of the business discussion that will take place later on in this presentation, you have to factor that in terms of how long the duration is. And typically speaking, in the Commonwealth Caribbean, it's 50 years after the death of the author. So as whoever is dealt to be the author of the copyright, you have copyright protection for 50 years after that person has died. So count January 1st of the year after the death, 50 years from that point, that's how long you have in copyright. It's a very long time. So you don't necessarily need to kill out your film in the first year, but we know that there's a life cycle for your film. So yes, you do want to have a very targeted marketing plan. You do want to release the film in a way that makes the most sense, but you can also consider the fact that you can re-release your film down the line. You can also use your film to create other additional subsequent works, or you may license your film to be used in documentaries or different elements. So it, of course, depends on the nature of the film that we're talking about, but ultimately you have 50 years plus, 50 years after you've died to figure out how to use your film. And then, as I said, there's a difference between author and owner. So the author is the person who's created the film, but the author may not necessarily be the owner of that film. So in a situation where you are an employee and you've created a film as part of your job description, as part of your employment contract, it may be the case that you're not the owner and actually that your employer is the owner of the film. So you need to be very clear as a filmmaker, producer, director, etc. What sort of contractual situation are you in? Are you an employee? Are you a contractor? Because the rules are different. So if you're an employee and your purpose of your employment is to make films, it's likely the case that your employer is going to own your film. However, if you're a contractor, meaning that you're just there for, there's a contractual agreement saying, I'm bringing you in to make this particular film, i.e. it's a contract for service rather than a contract of service, it might be slightly different. Because, for example, in the laws of Trinidad and Tobago, we don't have a commissioned works provision. So unless that contract for service specifically dictates who the author, who the owner of the film is going to be, the author remains the owner. So even though someone else has paid you for making that film, you can still technically be the author and the owner of that film by virtue of the fact that the contract did not speak to ownership of the film. So you want to be empowered as a creative to understand when you're signing an agreement what your rights are going to be at the end of that project. And more so, you want to be mindful as to how to negotiate that particular film contract that you're working on, because ultimately it determines whether you have control of the rights or not. So just because you've created it doesn't mean that you have control of it by virtue of being the owner. So the author and the owner could be different in that context. So when you do get copyright, it entitles us to a number of what we call exclusive rights. And the exclusive rights is just really what dictates what we can and cannot do with the copyright work as a third party. When we think about the word copyright, it suggests to us that it's only about copying. And that's traditionally what copyright was, that it was the right against copying, meaning anyone who wanted to copy the work had to get your permission. But that's very much a tangible way of looking at it. So if I didn't copy directly from the work, I'm not going to be infringing. But with the advent of technology, with the advent of the internet and streaming technology in particular, the reproduction right or the right to copy is no longer necessarily the most important. In the days of Netflix, HBO Max, Hulu, Disney Plus, etc., it's now our focus that actually the right of communication to the public is probably the most important one. that you as a creative and as a filmmaker want to focus on. So it's not just about stopping people from copying your film. It's also about stopping people from exploiting your film online or on television or on the radio without your permission. So just the mere fact of someone taking your film and uploading it to the internet, that's an infringement of your copyright. If they share it on YouTube, that's an infringement of copyright. If they share hyperlink that allows third parties to access it without your permission, that's potentially a copyright infringement. So copyright provides actually very, very broad and very rigorous protection to creatives. But again, it's just about being empowered to know what your rights are, to know what you can and can't do with it, and to know what you can charge people for. Because ultimately, the exclusive rights dictate what licenses look like, or what an assignment looks like in terms of what you are allowing people to do in exchange for services or in exchange for money. Ultimately, it's mostly about money. So when you're thinking about getting that Netflix deal, the Netflix deal is going to cover the right of communication to the public, the right to exclusively air or stream your film on this particular platform. And we'll talk about exclusive deals and non-exclusive deals to the back end of this agreement, but the exclusive rights are quite wide. So let's have a look at them individually. So reproduction, as we said, the right to copy. Public performance. No one can play your film in a public setting, i.e. for a guarded audience. So nobody can put your film in a cinema without your permission. We can't air your film on the grass in UWI on a screen without your permission. Right? You, as the owner of the copyright, have the right to stop that. They have to get your permission. Again, the right to communication to the public, we can't put it on the internet. So when you think about the internet, think communication to the public. Anytime your work is being used on the internet, it's communication to the public. And again, nobody can upload your work to the internet in any form or fashion without your permission. The right of distribution, for those of us who are still distributing on hard copies, whether it's on a flash drive, CDs, DVDs, memory sticks, Android TV boxes, however you're loading them physically, that comes under the distribution right. And again, no one can distribute a physical copy of your work without your permission. So let's say even the fact that you have burned these copies onto DVDs that you want to sell and someone steals the box of DVDs from your office, they can't put that onto the market without your permission. Yeah? So we need to be very mindful as to what we can control. Similarly, think about, I know this is way back in the day when there were DVD clubs, and before that, VHS clubs, and Betamax clubs when Betamax was still a thing. No one can rent or lend your work again without your permission. So, for example, if you put your work in the library, that's under the Rental and Lending Act, Rental and Lending provision of the Copyright Act. And in that context, the library can lend it because there are library exceptions, but they can't lend that necessarily. Let's say there's a film club. They can't lend your work, whether it's for money or not for money, without your permission. Yeah, so you have a lot of rights in that sense. Adaptations. You've made a film. Someone can't decide to take your film and then now make it into a book, or take your film and make it into a musical, again, without your permission. So even though you've made a specific film in a specific way, persons can't adapt that into a different sort of form of creative work without your permission. And then finally, importation. If you decide that you don't want your film to be made available, let's say in Trinidad and Tobago, you only want it to be available in Barbados, for example, and someone decides they've seen it in Barbados, they like it, and they want to bring it to Trinidad, they can't do that without your permission either. So as we can see, the laws under copyright afford a very wide and very powerful level of protection to right holders. So again, it's about empowering everyone to know that you have copyright. You need to figure out which copyright you have, i.e. what sort of subject matter you have, whether it's original, whether it's still in effect. For the most part, it will be in effect as long as you're alive, and then 50 years thereafter. So your estate also benefits. And then understanding, these are the rights that I have, so this is the power I have to negotiate. When I go to get a deal done for my firm, or I'm looking at investors, you could talk to them because they're going to talk to you about numbers. They're going to talk to you about accounting. They're going to talk to you about profits. You could talk to them and tell them, this is my value. This is the value that I'm bringing. This is what I control. And without me, you can't do any of this. So I have a say in this, and don't let them bully you. Because that's often what happens, that investors bully the filmmakers. Because creatives tend not to be trained in intellectual property. Creatives tend not to be trained in accounting. Creatives tend to want to focus more on the art side, the making of the film, and not get involved in the business side. And that's my experience dealing with creatives across the board, whether it's singers, songwriters, musicians, filmmakers, at the top and at the bottom. I've dealt with them. And there are these common themes that they are more interested in the creative side. And there's nothing wrong with that. You should be able to focus on the creative side. But again, in the world that we live in, where commercialization is really the sort of bread and butter of survival, you need to be more mindful of these things going forward. So we're going to talk a little bit about due diligence now. So you understand what rights you have. The question is, well, how do we understand and how do we map out what do we have? So we're going to talk about this in a real practical way to make it really easy for everyone to understand what you have in your practice, how to figure out what it's worth, how to figure out what to do with it, and the steps going forward in terms of dealing with it. And we call this due diligence. So I'll hand you over to my colleague, Dr. Perot.
Good morning, everyone. I'm Dr. Emma Perot, and I'm going to be taking you through the due diligence part of this lecture as well as the deals part. Now, due diligence, what do we mean by this? By due diligence, we basically mean ensuring the information you have is correct. So Justin just talked about a lot of different rights under copyright. He talked about 7 exclusive rights. So we know that while copyright is an area of law, there are exclusive rights under copyright. Because of the fact that there are several exclusive rights, there are different ways in which you can deal with all these different rights. He also mentioned the fact that you can have authorship, the person who has created it, and ownership. And while authorship and ownership can be the same person in some circumstances, we can also have situations where the author and the owner differ. So we see already that the fact that you can have different authorship from ownership and that there's so many rights means that there can be different parties involved who you might have to deal with. So when we talk about due diligence, there are several things we have to consider. So on the first side of the screen here, we have IP audit. IP audit, what does that even mean? An audit is basically seeing which intellectual property rights are in play. So what do you have, or what does the person you are contracting with have? If you are conducting an IP audit for yourself, you need to think, okay, what exactly am I dealing with? What is the work? And we're talking about film. So if there's a film in play, we know that there are different types of copyright works. We also know that each copyright work will have those exclusive rights. So we can see a lot of things in play. So you might have those rights, you might have control if you are also the owner. But what if you're dealing with somebody else? So you might be dealing with somebody else's film, somebody else's work, and you need to see, well, what exactly are they owner of? Or is it that they are author and not the owner? Because this author-ownership divide is very important. The owner is ultimately going to have the access to those exclusive rights, the rights to commercialize in these different ways. So whether you're dealing with your own work and you've collaborated with other people, you need to say, right, who are the authors and who are the owners of all these different things? Or if you're dealing with somebody else, who are the authors and who are the owners of those works? Now keep in mind, copyright is one area of intellectual property. You might also be dealing with something like trademarks. So if you have a film, you might decide that you want to register the name or any type of associated logo as a trademark. That's another thing you'd have to find out. Who owns the trademark? Is it a production company? Is it an individual? Is it the studio? Where exactly is ownership? So we see that once you have different rights in play, there's a lot of information that you're going to need. Now, usually, if you are the party being approached, you should be able to present this information to the person approaching you for whatever commercial deal you're entering into. But if you are approaching somebody else, they then present that to you. So the person who is being approached is meant to have that information, and that is the IP audit, the collection of all the information relating to the ownership and the authorship. So if you're approaching somebody else and you want to enter into the deal, you'd say, can you show me your IP audit? In other words, the collection of information that you need to know who owns what rights. Now, copyright is the focus for film, and we saw that there's many rights under copyright, which means when we go to seek permission, we want to make sure we're seeking permission from the right people. And I'm thinking, well, you have the IP audit, so you should know who these people are. However, we must also keep in mind that certain transactions happen within relationships that are not always accurately recorded in an IP audit. So while you would like to rely on the IP audit, and that is your starting point, this is where the due diligence comes in. So the IP audit is the collection of information that you are either presenting to somebody else or being presented with that deals with authorship and ownership on the different works and exclusive rights. Due diligence is making sure that information is correct. It's not that somebody's necessarily going to intentionally present you with wrong information. But it could be that some deal was not accounted for. It could be that there was a misunderstanding between parties as to this authorship-ownership divide. So if you're going to buy land, for example, you want to make sure the person selling you that land actually owns the land, because you don't want to turn up at the registry and find out this person couldn't sell me that land, and this is something that happens. It's the same thing with copyright works. You want to make sure the person who you are dealing with actually has the right information, which means you need to do some background checks. This is what due diligence is. So due diligence is not a particularly fun process. It does require probing information. It might require access to certain contracts that were in place before to make sure the information is correct and up to date. And it probably requires asking questions about how these exclusive rights have been dealt with by different parties. So while the IP audit is the first step, whether you are presenting your audit to somebody else or you are getting an audit presented to you, either side will have to be asking certain questions to make sure this is correct information. You are verifying that information. What you don't want to do is just go solely on the IP audit, is your starting point. But if you go solely on that, and there's incorrect information there, you can spend a lot of time on a deal that the other person might not have the authority to enter into. And you don't want to waste your time if the other person can't actually be part of this deal. Perhaps they were the author and they have since assigned rights, or they've entered into an exclusive license which prevents them from dealing with you. You want to make sure this information is correct. So due diligence is making sure the IP audit, all the information that you presented, is actually correct, and it's a very important step. Failure to do due diligence has serious consequences, and this is not just limited to film. This is not just limited to people who are in certain fields. This happens across the board. So many years ago, it was Rolls-Royce and I think Volkswagen or some of those car companies entering into the deal. I can't remember the exact names of the companies. The point is, the deal involved the rights to make the car. What the legal team did not realize, and they should have because these people are trained to do this, is that the trademark to name the car was held by a different company. And they didn't contract with that company, which meant they entered into a deal to be able to make a certain car, but we all know how cars work in terms of branding. Yes, you want the car, but you want it to say BMW or Porsche or Jaguar or whatever it is. So if you can make the car, but you don't have the trademark, you can't go and then use that name on the car. So that was a serious lack of due diligence there, because they did not realize that the trademark was actually held by a different company. Again, this is why it's important. Even if you get an IP audit, you have to make sure, is this information accurate? Does it represent all the information I need? In that case, they should have realized that the trademark was not held by the company they were contracting with, which meant they would need an additional contract to be able to call the car what people know it as, what the commercial value is. So when we do our due diligence, we will then know, well, who are we asking permission from? We go on to the contract and we'll see the different types of permission we might be asking for, but when we find out, right, we verify this information, we think this is correct, we're going to ask this person for certain permission to deal with these works, or we're going to grant this permission to the other party. So we are seeking the permission. The reason we want to do this is because we don't want to be infringing copyright. We wouldn't want somebody to infringe our copyright. We know we have these rights that Justin talked about. We don't want somebody just coming and taking parts of your film and putting it online and doing things to infringe. But similarly, you would not want to do that to somebody else, or you shouldn't want to do that to somebody else. So you have to make sure you're seeking the right permission. And remember, because there's so many different types of copyright works, you need to be making sure you have the permission for all the works. So for example, let's say you hired somebody to make the score for your film and you've entered into a deal there, but you decide, well, there's one existing song that this person hasn't created that I also want to use. You have to find out, where are the rights for that song vested? Are they vested in a collective management organization? Do I go through an organization? Does the individual have the rights? Do the producers of the song have the rights? Who exactly has these rights? So it's a bit of research that has to be done to make sure you are getting that permission. If you don't get that permission, you have your film, you have the song in it, the copyright owners find out that the song is in it. That's going to affect your film. They can make you pull that film, or they can simply say you need to remove this and pay us for the unauthorized use. And then you're not in a great position because you have indeed infringed copyright. So perhaps you wouldn't actually go to court, but you're still not in the less bargaining position than you would have been in if you sought permission from the outset. That gives the person to say, yes, I will allow this for this cost, or no, I'm just not going to allow it. But if you do it and then seek permission after, you are at their mercy because they do have the ability to then bring a claim in court, and that's something nobody wants to go through. So you need to make sure you are seeking permission from the right people and seeking permission for all the copyright works that you are incorporating. In terms of contracting, you want to know, well, what exactly do I want to be able to do with the works I am contracting for or contracting out? Do I want the person to have exclusivity? In other words, am I going to exclude myself and only allow this other entity to deal with the works? Do I want to have a sole relationship where both parties can deal with the works? Do I want a non-exclusive relationship where I can do a deal with this person, but I can also do a deal with all these other people? So what exactly do I want? Or do I want to go full assignment? Do I want to divest my rights, give them away for money? Do I want to do a full assignment, but I have to understand if I do that, then I'm not the copyright owner anymore. And in fact, if I do something that amounts to infringement of those rights, I will in fact be infringing copyright. So I need to be very careful as to what exactly I want. Now, in terms of what we're looking at, again, we have the literary and dramatic works. So things like the script, the screenplay, musical works, the songs, the sound recordings, the actual recording that has taken place, performance rights. Your actors and actresses have rights in their performance, image rights. Now, image rights is an area that is not very well developed in the region, but it's something to still be aware of. So image rights goes by different terms in different jurisdictions. In the UK, there's no such thing as an image right, but there is the law of unregistered trademarks called passing off. And there have been successful cases where people were able to claim and say, my persona, my likeness has been used without my permission. People thought I did give permission, therefore you need to pay me. Most famously in 2013, Rihanna sued Topshop, which is a UK high street store, for using a picture of her face on a t-shirt. And she won that case to a very high level of legal fees and damages that the store had to pay. They did not anticipate her winning the case, or else they obviously would have settled, or they would not have proceeded because she actually rejected permission. She wasn't going to allow this to happen. But they thought because the law was not as developed that perhaps it wouldn't succeed. But that then changed the landscape and basically affirmed a previous judgment from many years ago that this is a possible infringement. In the US, though, it's a lot more strict. The US has what is called the right of publicity, and this prevents any type of commercial use of an individual without their permission. It differs from state to state, with California, unsurprisingly, being the most expansive protection. So in California, people can get protection for their name, voice, likeness, signature under the written law, the legislation. But under the common law, so the case-developed law, they can also get protection for what is known as their identity. Identity has been interpreted very broadly. Identity has been interpreted as a distinctive race card that a driver uses. It has been interpreted as the way in which somebody dresses when that dress was actually put on a robot. So a very broad interpretation. Now, generally, this area of law, there are exemptions for expressive works, or rather defenses that can be applied. But obviously, if you are directly dealing with somebody, you need to know what permission do you have when you're dealing with them. You might have a contract that the person is appearing in your film, but does your contract also cover any type of advertising, any removal of stills that you're going to put on posters? What about merchandise? So we know Black Panther 2 is out, very popular. You can imagine how much they are making from their merchandising deals. Those deals would have to be negotiated with the actors and actresses. You can't just go and put their face on a jersey just because they appeared in the film. So that is an additional deal that you have to make. So even when you're thinking of the film, you're thinking about what are the other commercial steps I take? Of course, any type of branding and merchandising. The actors and actresses need to be accounted for. And you have to think, well, what permission do I actually have in relation to this branding and merchandising, in relation to making the posters, making the t-shirts, and we know now that merchandise goes to things like phone cases, so it goes beyond the normal just wearables to a host of different goods. So we need the permission under the image rights. Now, again, this shows us that there are a lot of rights we are dealing with. It seems like it's a lot of work to do all of this stuff, and it is a lot of work. Make no mistake about it. This is not some type of thing that you can do in a few days. This is a lot of things to consider. The reason, however, that you want to consider these things is because you don't want all the work that you've put into your film to then be halted because you haven't done something in terms of making sure you've done your IP audit and your due diligence and had your contracts in place. Because what could happen is that somebody who is one of these rights owners who realizes their rights are being infringed could go to the court and say, I want to injunct this, I'm going to apply for this to be halted, and then we're going to go to trial. Now, we know the court system is not fast, but they can issue an injunction fairly quickly. And when we say injunction, it is an action to prevent or force somebody to do something. So in our local context, there have been threats against FETs, party promoters, for failing to seek the correct copyright licenses to play music in the FETs. So if you ever go to a FET and you realize that there's people moving around the DJ and there's a little kind of tense feeling in the air, it could be that there's a discussion going on right now about, did the promoters seek the correct licenses? Can they actually play the music that they are playing here? If they don't have that, then the FET can be shut down. The music can be shut down at least, and without a music, you're not really having a FET. So these are very real things that happen, and often what happens in the FET scenes is that the due diligence hasn't been done. So it's not that the promoters are trying to just, I don't think they're trying to disregard copyright. It's that they have not necessarily done the due diligence to make sure they have gotten the correct permissions. So getting the correct permissions is very important, especially if you're doing something like a film, you're putting so much work into it. You want to make sure that you are protected. You want to make sure that anyone else you are dealing with, you are on the same page as them. And if you're doing with any third-party works, you want to also make sure that you are doing the right thing in dealing with those third-party works.
So just picking up on that note from Emma, that there are multiple rights at play here. We have to, and I really want to hit home and reiterate this key point. Any single one of these right holders can stop your project from happening. It doesn't have to be the case that a bulk of the rights need to stop your project. Any one single right holder. If you did not take a license from the screenplay person, that's very significant, obviously, and that's the sort of underlying basis of the whole film. But it could be as simple as one song that you've included in your film that you didn't license and your whole film gets shut down. So that's what you're playing with here. You don't want to take chances, right? And the same, and Emma made a really good analogy to say that when you're buying a piece of land, you go to the land registry or you take your lawyer and let them check and see who owns the land. Is the land that you're buying actually what is described on the deed? Is there a deed? Am I dealing with the right person? The bank asks you these questions if you're going for a mortgage. So if the bank is asking you these questions when you're going for a mortgage, why aren't you as a creative asking these questions in your own film project, right? Because you have to treat your film like a piece of land, like your house, like any other serious matter that you have in your lives, because it is a serious matter. It is a big deal. And I want to sort of contextualize all of this in a really practical example, and I'll use the presentation we're doing today. So these lecture slides that you're seeing here, these are mine. This is my copyright. Yes, I have given, and I will say in advance, I have given permission for all of this to be included and live streamed and recorded and uploaded to YouTube. So it's all good. I'm not going to sue you all for copyright infringement. But these lecture slides, this could not be included in the recording of this, which would then stay up on YouTube without my permission, because I am the copyright owner of these slides. Emma and myself, we are giving this presentation. These are our words. Even though I didn't write this down, this is our copyright work. This is a literary work, because this could be reduced to writing. This is actually being recorded. So this solidifies the copyright that we have in this presentation. So our words that I'm speaking here, this is ours. And again, this recording could not be put on YouTube. This live stream could not happen without our consent. Similarly, I'm giving an oral presentation here. So therefore, I also have a performer's right in this. And again, none of this could go online. You can't make a recording of this without my permission. Right? So I could kill this on YouTube in a number of ways. And I'll talk a little bit about how this happens, how you get it killed online. But beyond that, I also want to talk about the people who I'm seeing in the room here. I know you can't see them behind the camera. But I'm going to point at the cameraman here. What is his contractual arrangement with this setup? Because ultimately, he's recording this, he's filming this, and actually the footage that is being recorded here, technically speaking, in the absence of a contractual arrangement, is his own. So It's not recorded. It doesn't matter. The point is, without him handling the camera, or my friend here, lady handling the camera over here, without them, there's no visual feed. So they actually own the copyright in that audiovisual work, which is unedited, raw footage. They still own the copyright in that unless there's some contractual arrangement in a different context. To say that Film TT or the UWI.Film program, etc., owns this. So even in a classroom setting, there are copyright works being created. For example, you all are all students. Well, we have some students here at the university. You all do a capstone project. Guess who owns that? You own that. So even though it's part of your program, you own your capstone project. And it's the case that a lot of you times, you hear horror stories about you do your capstone project, and your lecturer takes it and puts it out there as their own work. That's copyright infringement. Yeah? I hope that doesn't happen here, but if it... No? Okay, good, very good. But if it were to happen, you have rights to sue them because you put that project together. But even in doing your capstone project, a lot of you will take the capstone project and then want to actually turn that into a feature-length release when you finish your program. And you need to make sure and secure all of these rights, because even though you're doing it in the context of school and let's say the severity of the problems that may arise may be very small, you're not going to get sued while you're in school. The minute you put it out there, the minute that you start to make $1, that's when the problems start to come up. Because what usually happens, when you deal with the people that own these rights, they say, well, you're in school, man. I'm going to take nothing from you now. Or use my friend, or use my cousin, or use my brother. No worries. The minute they start to hear that checks hit in your bank account, all of a sudden it's like, well, where my share of this? And you didn't have a discussion about it. And that's usually where the problems arise. Or alternatively, the problem is brought to your attention when you try to release the film through a distributor, whether it's online or in physical, and then they ask, well, hey, where's your due diligence statements? Where's your copyright clearances? Did you get permission from all these people? And you're like, what? I don't have any of this. And all of a sudden, that now kills your progress in terms of releasing the film. And now you have to go and do all the due diligence that Emma would have spoken about, and that could take a long time. And then by the time you come back to them, they're like, well, okay, well, no, we've moved on to the next project. We don't want your project anymore. Yeah? So be as proactive as possible in developing this. Be as mindful as possible in understanding what is included in your film. So if you know that you're including musical works, make sure that the person who's created that work, the lyricist, the composer, the person who owns the song recording, that they've all signed off on it. As far as possible, either use royalty-free music, or if you're commissioning the creation of music, make sure that you have a contractual arrangement with them and they understand where this music is going to be made, where the film is going to go, and what they're going to get in return. It might be the case that they get, some upfront money, or it might be that they're getting royalties. Make it abundantly clear to them what they're going to be entitled to. You don't want to have that discussion at the later stage, because then you start losing negotiation power. The more that you're able to focus on these things at the beginning before money is starting to be made, the more control you have. Yeah? So with that, we'll talk about contracts. And I know this is where it starts to get a little bit sticky. And this is where, as creatives, we tend to want to switch off. Yeah? Because nobody really wants to have to deal with this contracting stuff. I've heard from artists, I've heard from performers, I've heard from filmmakers, this interrupts my creative flow. I don't want to have to be thinking about this while I'm in pre-production. I don't want to think about this while I'm in the production phase. I don't want to think about this when I'm in post-production. So the question is, well, when are you going to think about it? Normally, the issue or the answer to that is, you think about it when it's too late. You think about it when a problem arises. So what I try to preach is proactive contracting. Try and have all your ducks lined up before you get to the point of having to actually rely on it or having to actually need it. You already have it in play. Yeah? So what I'm going to do is really just talk about what the value of contracting is and how we want to do it. I'll then take you through some of the key contractual clauses that you would like to see in your film contracts, whether it's you and an investor, it's you and the crew, it's you and the composer of the music who's scoring the film, you and the animator, whoever it is. Anybody who's involved in a film project, you need to have a contract with them. So first things first, you see this handshake business, throw away that. Get your contracts in writing. They don't need to be big, long, 125-page documents. They don't need to be written in legalese. They don't need to have any Latin terms in it. None of that needed. As simple as we having a discussion here, you could record in writing what the agreement is. I want you to create animations. I want you to create 6 animations for this film. the animation should look like this. So I give a description. I'll pay you $500 for that. That's a contract. As simple as that. It does not need to be this big formalistic agreement. You could write, I mean, there are contracts written on the back of napkins. I advise you against that, right? Type it out. Make sure it reflects the discussion that you had. Have both parties sign it. Give both parties a copy. You have a binding contractual arrangement. Remember, at the end of the day, as a matter of law, you only need 4 things for a contract to be valid: an offer, acceptance, consideration, and intention to create legal relations. So the offer, I'm telling you what I want you to do, or you're telling me what you want in exchange for what you're doing. The agreement is that both parties say, yes, okay, good, we're going ahead with this. Consideration. Consideration is the exchange of value. So in the context of the example that I gave where I want someone to animate something for my film, they're doing the animation. That service is their consideration. My consideration on the other end is me paying you for that. And it doesn't have to be money. It could be an exchange of services. It could be bartering in terms of I'm giving you some goods and you're giving me the animations. I'm helping you out with your film. You're helping me out with my film. But just record that. Let the record show that this is the deal between these two people, right? And that's it. That's all you need for a contract. There's nothing else required for a legal agreement. So have your contracts in writing. Keep it very simple. At the end of the day, both parties need to be able to understand the deal. Where contractual disagreements arise is because the language in the contract is not clear, or the parties were not very clear when they were negotiating, and what is reflected in the contract is unclear, or is not subject to agreement. Yeah? So have the negotiation, draft the simple document, have another chat about it, sign it, good to go. Yeah? But you can do this on your own. You don't need lawyers to get involved in any of this, right? And under our laws, you don't need a lawyer to sign a contract. Think about every time you go to the supermarket and you buy cereal, that's a contract. You're giving them their money, they're giving you the cereal, that's a binding agreement, that's a contract, yeah? So you don't need to get lawyers involved, you don't need to spend money to do this once you understand what you're doing, and again, keep it very simple. However, if you're dealing with a more complicated deal, let's say you're signing up with Netflix and they send you the 120-page document, know when you need to seek advice, yeah? So at that point, maybe it's in your best interest to get legal advice, or at least get the advice of someone who is a specialist in intellectual property law, yeah? Because even then, it might be the case that a bog standard lawyer that has no specialization in IP may not be useful to you because they don't understand the specifics of intellectual property law and intellectual property right management. So you really ideally want to get an expert lawyer or someone who is an IP expert. Yeah? And in the country, in Trinidad, in the Caribbean region, there are a few persons who are IP experts. There are a few IP expert lawyers, so there are persons available to you. And I mean, it's not going to necessarily be cheap, but think about the value of getting the deal done in the proper way versus you losing out on an opportunity, or you getting sued for copyright infringement, or worse yet, your film getting killed dead. Yeah? Because you don't want that to happen. So where in doubt, seek not just permission, but also seek advice. Yeah? So in terms of permission seeking, we would have covered this in terms of the due diligence. Anytime you're using anything that comes from a third party, ensure you have a contract with them. But as far as possible, do all of this in advance. Before you start filming anything, get that done. When you're storyboarding at the beginning, right, you're going to start thinking about the locations I'm using, the actors or actresses I'm using, the storyboard, the storyline on the storyboard that I'm going to use, or the plot, or the themes, all of these things, the music that I want to use. When you have all of that, all those ideas in mind at the beginning, get permission straight away. Don't wait until the back end, because what happens, and I've seen this happen when I've dealt with people, they've done the whole film project, they used the music throughout the entire project, they didn't get the license, they didn't get any agreement, and then the party on the other side is being unreasonable. They're saying, well, I want $100,000 to use this music. You then don't have $100,000. What are you going to do at this point? Are you going to then re-edit the film and take out all the music, of which the music you decided to use is built into the theme of the film? Right? That makes it a problem in terms of actually making the film work in the way you wanted it to work. Or alternatively, are you going to find $100,000 to pay them? And if you don't have the $100,000, what are you going to do? So you have that situation where you're stuck, right? And it's not going to be very helpful to you. So understanding that these are the basic elements of contracting, who needs a contract? And I've reproduced all the people here that I tend to think about in terms of a film project. You all could let me know in the audience if I'm missing anyone here. So the producer or director, just because you're the boss of the film, don't mean that you shouldn't have a contract, right? You should have contracts, maybe it's with everyone else involved. Alternatively, you might be the producer or director by virtue of being an employee, or you might be a producer or director by virtue of being a contractor. So you definitely want to have a contract as the producer or director, or if you are the film company, you want to hand your producer or director a contract, right? You want to make sure that they are going to do what the film project requires them to do. Your film crew, right? So whether you're a camera person, whether you're a song person, whether you're a graphic designer, whoever it is that you're involved in the film project, they all need contracts, right? Performers. Of course, you need to have your actors and actresses sign agreements to be not just to do the work of acting in the film. What you also want them to include are their image rights, because they are going to be the face of the film. You're probably going to put them on the poster. You're probably going to use them in the marketing campaign. What you don't want to happen, and it has happened, is that the person agrees to be in the film, but they didn't agree to be their images to be used on merchandising. They didn't agree for their images to be used on the marketing campaign. And then, well, the question is, well, how do I market my film? How do I actually display a trailer if they didn't agree to that, right? So, again, heading off problems proactively. The musicians, the composers, the person scoring the film, we talked about this extensively already, they need a contract too for the creation of that music. And in specific, you want them, when scoring the film, to create original music, meaning they did not copy that music from any third-party source. If it is the case that you're getting them to score something specifically for your film, you may also want them to do what is called an exclusive contract, so they don't go and sell that music to someone else who also then includes it in their film, right? It's also about building a competitive advantage in relation to the work that you're creating. Yes, it's a work of art, but also you want that work of art to be unique. You want it to be special, and the way to do that is to build into your film project exclusivity so that other people can't copy elements of it, and especially those elements that you don't own, because you don't necessarily own the score. You may be taking a license. Alternatively, you can ask them to create the score and ask them to assign it to you. So that way you own the score as well. Yeah? And that's the best case scenario. But a lot of times that doesn't happen because creatives don't necessarily want to give ownership up for whatever they've created. You'll also have contracts with your investors. They've given you money. They want something in return. You want it to be abundantly clear what that return is going to be. Yeah? The distributor, this is going to come in the post-production phase, or maybe towards the end if they have signed you up to create this film. How is the film going to be distributed? What are the platforms it's going to go on? Is it about TV? Is it about radio? Is it for streaming? Is it for live streaming? What's the situation? Where is it going to be made available? Is it going to be across multiple networks? Is it one network? How is it going to work? Yeah? Third-party right holders generally. So if you have used any content from anyone else that you don't own, get their permission, right? And again, it comes back to that due diligence. So in truth and fact, any single person that is touching anything in your film needs a contract, right? Whether it's the caterer, whether it's the actors, whether it's the person behind the camera, whether it's the photographer, designer, the editor, whoever it is, they all need a contract, and ideally a written contract. Don't rely on the handshake and the bongs from your partner, yeah? Because that tends to go wrong in the long run. So, negotiation. How do you do all of this? So you know now that everybody involved needs a contract. So how do we actually start the process? So it begins with the due diligence analysis. What rights are at play? So once you identify what rights are at play, you know what you need to contract for. You also, at that point, know who you need to contract with. So you need to now do cost-benefit analysis, because you may not be able to afford all of the things that you need. So give priority to the things that make the film work. If it's an additional bit of music that you want to use any credits, that may not be as important as the music that is going to be used in the intro scene of the film. Yeah? So yes, we have grand desires and we have grand needs, but we have limited pockets, right? So we need to be clear, don't shortcut here, and don't feel that because that man is a small man over there, he's not going to sue me. Right? Or because he have no music release, that he's not going to sue me, or that he can't sue me. That's not the reality. Yeah? And the more successful you get, the bigger target it is going to be on your back. So you really want to be very clear as to how all of this is going to work. So when you're negotiating, you know what you want, you know who you need to get it from. you also need to know how much can you pay. What are you willing to pay? What's the budget going to allow for? So all of these things need to be done in advance, because what you don't want to happen is to say, I want this, I need this, I used it, and then they come with the $100,000 talk at the end and it's like, oh crap, I can't afford it at this point. What am I going to do? So negotiation, again, proactive dealings will help you. It's probably also going to be the case that the price is going to be cheaper when you get permission up front and they tell you the fee, as opposed to when they vex and sour at the end that you use the thing without permission and they want to charge you to bust your head. So it's always better to do it in advance proactively, right? And ideally, and I know this may not always be possible, but ideally, before you start production, you should have all of these agreements wrapped up. Or at least, in the worst case scenario, you've had the conversation with everybody and they've given you a verbal agreement, at which point you could develop the paperwork and send it to them to sign. Of course, some people may change their mind as you go, or the terms or the conditions may change a little bit, but at least you've had substantive agreement about it. It's not going to be a surprise to anybody involved what the firm is about, where the firm is going to go, that sort of thing. Yeah? And document the process. Don't have phone calls alone. Yes, we know we use Zoom and Teams and all of these things now. Ask if you can record the conversation, right? And offer both parties a copy of the conversation, because you don't want them to feel that this is a one-way street, right? It's a dialogue. It's not a, unilateral conversation. It's a dialogue between the people. So document it, all right? If you're talking on WhatsApp, save the WhatsApp chat log, yeah? And have a copy of that on your computer in case your phone fall apart or whatever the case is, or the software goes buggy. Document it, because what you can normally have to refer on if there's a dispute in the agreement is, well, this is the conversation we had behind the agreement. And that usually gives you a lot of help if you have a problem in interpretation of that contract. Yeah? So protect yourself as far as possible. That's really what all of this conversation today is about, protecting yourself as a filmmaker. Yes, it's about empowering you as having more knowledge, but it's also to protect yourself. So very, very quickly, because this is something that we might actually, for example, in entertainment law that we teach here at UWI, we will spend 3 weeks to a month talking about contracting. Yeah, I get to talk to you about contracting in the space of 15 minutes or less. So in a contract, what you want to be very, very clear about is ownership. Who is going to own the film project? So when you bring all the parties together, make it very clear what they are going to be entitled to, because people ultimately have these ideas that, oh, well, I'm involved in the film, I own part of that film, or I am the boss, I own the whole thing. Make it very clear on paper in a contract who owns what. And ownership could be you own 2% of the film, you own 10% of the film, you own the whole thing. Just make it really, really clear who is the owner. Yeah? So who is the owner is ultimately going to dictate who has control over the commercialization of the film. Who has the right to distribute the film, or to meet with the distributor to put the film out there? Who can put the film online? Who can license the film to Netflix? Who can license the film to CNC3? Who could enter the film into the film festival? Right? That's the owner. The owner is the only person who could do that. And where you have multiple owners, all of the owners have to agree. Yeah? So what you might want built into your film project are bylaws for the film company to dictate the control and the direction of how the film is going to be used. That's very, very important. So it's not just a matter of intellectual property law, it's also a matter of company law, and it's also a matter of like running a business. It's a business at the end of the day. That's what you're doing. Yeah? So ownership, key. In your contracts, you want to see terms on licensing. If you are borrowing works from someone else to include in your film project, you need to be very clear as to what those works are. Identify them. If they're, let's say, they're film bits, like B-roll or something that you include in, make note and make reference to what the B-roll is. If it's photographic works, include copies of the photographs into the contract to say, it's these photos that are included under the deal. If it's music, get a copy of the music and say it's attached to the annex or the schedule to the back of the contract. So no one can dispute what the actual work in play or in the context of the contractual agreement is or are. Yeah? Ensure you're dealing with the right person, so you want them to agree and give a guarantee that they have the power to license this work to you or to assign this work to you. And more than that, you also want a warranty that they have created this work themselves, that they haven't copied it. Because the worst case scenario is you take the license from person X actually copied the work from person Y then comes and sues you. So you want a guarantee in that context that person X has actually created the work so that you're not going to be open to liability from person Y. Yeah? And we'll talk a little bit more about guarantees in a little bit. In terms of payment, how much money? Be very, very clear as to any discussion of money. Is it an upfront payment, a one-off payment? Is it I pay you some now and I pay you the balance when we're done? Is it that I'm going to give you royalties on the film, so I'm not giving you any money up front, but when we actually release the film, you get 5% of the proceeds? Is it a mix of royalties and money? Be very clear how you're going to calculate the royalties. Don't assume that royalties just means a percentage of the earnings of the film. It ideally should be a percentage of the net profit of the film. So the film cost $1 million to make. That is an expense. Take that out first. When you've made money on the film, let's say you've made $2 million, you know that's $1 million out, so there's $1 million left. You have to pay taxes. Take the money to pay income tax or corporate tax or anything else out first. Let's say that's another $250,000. All of a sudden, that $2 million in revenue is now only really $750,000. You want to pay the royalties on the net profit of the film, because if you don't do that, you end up being out of pocket. So let's say you're paying off let's say 10% off of $2 million, that's $200,000. You have 1.8 left, and then now you need to take out the $1 million, so you have 800,000, and you take out the 250,000, or you have 650 or less. So you've ended up making a loss on the film. So you need to be very clear how you're calculating royalties. Don't leave it up to people to understand what royalties means. You, as a contractor, dictate what royalties mean, right? So explain what the royalties mean. In terms of a film project at large, you don't want people knowing what you're doing necessarily, because then they could copy your ideas. And remember, ideas are not protectable under copyright law. It's only the expression of the idea. And things like themes and plot lines may not be protectable in and of themselves until they're fully expressed. And you're not going to fully express these things until you've done making the film. So let's say, let's use one of the examples. Everyone familiar with the Da Vinci Code written by Dan Brown? There was an earlier work called Holy Blood, Holy Grail. The premise of both of these books is that Jesus Christ had a child with Mary Magdalene. So the owners of Holy Blood, Holy Grail attempted to sue Dan Brown for using that storyline in his later novel, the Da Vinci Code. The court said, no, you don't have any protection in that plotline of Jesus Christ having a child with Mary Magdalene. So there was no claim, and the infringement suit failed. Well, you don't want that to happen where you've written this nice story, you're starting filming it, some intern on the project sees the storyline, and then they run off and make a film on the side, beat you to production, put their film out first, and all of a sudden, you've lost the market capacity to now put your film out there or to compete with it. So everybody who's involved in the film project, every single person who's getting a contract, have a non-disclosure involved in that contract. So there's an obligation of confidence, meaning anything that they learn from this film is held confidential until the end of the film. Yes, you can't sue them for using the themes, the plots, etc. as a matter of copyright, but you can sue them for a breach of contract. Yeah? And that could be the difference between the make and break of your film, right, if things leak out. Also, you need to be mindful as to the way in which you're sharing information. Need to know basis, definitely. But more than that, secure communication lines. Don't be sending your film script by WhatsApp, yeah, because you don't know who that forwarding to, right? And ultimately, you can't control how people are going to share it. But at least try and dictate the flow of the conversation. It's not just about the law. It's not just about being proactive legally. It's also about being business savvy. It's also about being practical, yeah? All of these things have to coalesce in order to be an effective filmmaker or to have an effective, efficient film project. So I would have spoken about warranties already. Anytime you're dealing with a third party for the use of material, you want a guarantee from them that this is going to be fit for purpose, as in designed to the specs that you wanted it to be. They didn't copy it from somebody else, and that they are the owner. Because if you don't have those three things happening, you're opening yourself up for legal liability. So the flip side of the coin to warranties, or as we call them, guarantees, is indemnities. So if, for whatever reason, there is a breach of the warranty and you're going to get sued, you can limit your liability. You can't prevent yourself getting sued. But when you have the indemnity in the contract, you can pass that liability on. So let's say you get sued for $1 million and you lose the case. If you have the indemnity in there and you've lost the case because what you've used from the third party is actually infringing material, you can pass that legal liability onto them and more so pass the financial liability onto them, which means that even though you've lost the case and you have to pay $1 million, you pass that financial burden onto them, they have to pay the $1 million. So liabilities need to be minimized and need to be managed. So your warranties and your indemnities absolutely have to exist in any contract that you're dealing with, whether it's the caterer right up to producer and the director. Yeah. So those are really, really key things that you may not feel super confident or comfortable dealing with at this point, but that's in those contexts, that's probably where you need to get a little bit more of expert opinion, a little bit more of advice. And one thing I want to note at this point, just because you see contracts online, don't copy them and paste them into your own use. A lot of film contracts are based on US law, which are not going to be applicable here. One of the things I'll mention now that I've seen frequently, and this is from, unfortunately, big lawyers in this country, works for hire. And I'm sure that you're all aware and understand the term works for hire. That's an American concept. That has zero bearing in Trinidad and Tobago. That has zero bearing in the Caribbean. So if you have a contract that says anything about works for hire, unless they've defined works for hire as a term under that contract, that means absolutely zero. You're getting zero protection there, and it creates an issue as a matter of copyright law because that concept does not exist in the Caribbean. Yeah? So now we're getting into the sort of wrapping up the contractual element. So we've spoken about getting permission to use things. We've spoken about protecting yourself. Let's talk about making money now. Yeah? So when we talk about making money, how are you going to commercialize the film? You want to be very clear as to where the film is going to be used. You want to be clear as to the scope of the license that you're granting Netflix, the scope of the license you're granting CNC3. When you grant CNC3 to let's say, air a movie on a Sunday morning, it's for a specific time slot or specific audience. Is it that you want them to broadcast it on live television and put it up on the stream on their website? Is it limited to the TV? What is the story, right? So you control the distribution of your film. You need to not get taken advantage of, and you need to be aware that how wide the clauses are going to be in the contract that you're signing. Yeah? So figure out what your targeted distribution mode is. Figure out how many times it can play, what times it can play. Can you include ads in your film? Is that going to conflict with the sponsors of your film? These are all sorts of considerations that need to be borne in mind when we talk about commercialization. Yeah? So it's not just about I'm doing a deal with Netflix. I'm doing a deal with Netflix, but is this going to allow me to do a deal with HBO Max as well? Is this going to allow me to do a deal with, or let's say hypothetically, I put it on Netflix, can I also still enter it in a film festival? You need to make it very, very clear, exclusivity-wise, whether I can use this film in simultaneous ways with different entities and different contexts. So you need to control the use of your film. Yeah? So exclusivity is really the key element here in terms of commercialization. As far as possible, well, I suppose it depends, right? So if you want to make the most money, you need an exclusive deal, meaning Netflix pays you exclusively to air your film on Netflix. It can't show anywhere else, and because of that, they're probably going to pay you a bigger check. If you're giving them a non-exclusive deal, meaning it can air on Netflix and a competing streaming platform, it may be the case that they're not going to pay you as much because they don't have exclusivity over it. So for you, it's now what do you want to achieve? Is it that you want your film to play as much as possible and as far and as wide a scope as possible? Or alternatively, is it that you want to make the biggest dollar? Right? So that's up to you. You need to figure out how you want your film to be distributed. And then the finances, right? So this is where I'm going to close up in terms of, let's say, key contracting elements, in terms of financial bits. Don't forget that you may have investors and sponsors who would have contributed to your film. Do you need to pay them back? How are you going to do that? You need to pay your taxes, right? So in the film company agreement, with the different elements involved, right? If you're a director in a film company, you need to be clear what your responsibilities as a director are, what your responsibilities as a manager of the film company are, etc. Right? And that includes taxation. Who's going to pay the taxes? Are you all going to hire an accountant? Is it that you're going to have some sort of business manager involved, right? And these are things that nobody thinks about, but ultimately still need to be included in your contracts. So we would have spoken about contracts at large. We would have spoken about different key contracting terms and elements. Not every single contract are going to have all of these things included in one, right? It's a matter of context. But these are the key things that you need to be aware of when you're running a film project If you're the managing director of the film project, for example, you need to be personally aware of all of these things. Yeah? So we'll wrap that up in terms of contracting elements here, and I'll pass you back over to Emma, who will take us through the actual deals at the end. So what sort of deals do we want to strike?
All right, so in terms of deals, obviously everything we've looked at before is relevant for this final deal. And when I say final deal, what is it you're trying to achieve with this film? Is it that you have made the film, you've done all that contractual stuff, and now you've decided, right, I've done what I want to do, I am going to assign this. In other words, give this to somebody else for a payment exchange. They then take over and decide how they want to commercialize it. Once you assign, it means you are not part of this anymore. You can assert your right to be named as the author, the producer, the director. You can assert certain things to say, I want to be attributed. But at the same time, you have to accept that that is where your control would end. So that is called a moral right. That differs from jurisdiction to jurisdiction. So while you can say, right, I am giving you this, I still want to be named in the credits, for example. Whatever the person decides to do with it, it's on their terms because you've assigned, you have divested your rights. You have said, this is now yours. I need you to still name me, but it's yours. And keep in mind, if you do an assignment, you have entered into that deal, you've gotten the payment for the assignment, they can decide that actually they don't want to do anything else with this. They can decide, well, I got this, and maybe they decide they're not going to do anything with it. They might actually do that to prevent any competition. This is something that happens in many different fields. So for example, in intellectual property issues, for example, pharmaceutical companies, they might get patent assignments from smaller companies, not because they want to use it, but they want to stop competition. So if you go into an assignment, you have to understand that the person could be free to not commercialize it. It might not make sense as to why they want to do that unless there is an issue that they don't want this film out there, they don't want this competition. That being said, you have to think, well, what do I want? If it is I really don't want to do anything else, I'm willing to just take my upfront payment and let them commercialize on their own basis, even if that means not showing it, then okay. But I assume that usually if you've gone into all this effort, you want your film to get out there. So just keep that in mind as to what you're entering into the assignment. You'd have to have those discussions up front because you can't necessarily force them to do anything once that assignment has taken place. What you might want to do instead is enter into a license. There are different types of licenses, and we've mentioned some of these words before. If we're dealing with Netflix, most likely they want an exclusive license. An exclusive license means that they have the ability to commercialize. Now, in that, you'll be putting what the expectations are, and most likely if it's Netflix, they're going to tell you what they're going to do with it. But there'll be certain obligations within the contract, and it's important to make these obligations very clear. Will the film be shown for a certain period of time? Which countries will it be available in? Will there be options for renewal of this agreement? All this is very important. And if you enter into this exclusive agreement, it means you cannot then go and give this to some other distributor during the term of this agreement. So that exclusive agreement also means that you can't go and show it yourself. Exclusive means you're excluding yourself and everybody else. You might instead want a sole license. That means you can commercialize and the other party can also do so as well. Now, realistically, Netflix is probably not going to agree to that, but different distributors might allow that. They might say, right, we are going to do it on these channels. You can do it on these channels. We'll divide how we're going to do it. Alternatively, you might want a non-exclusive license. So for example, if you're entering into a film festival, you might want to enter into multiple film festivals. You wouldn't necessarily want to be tied to one. So you might say, right, here's a non-exclusive license to show it at this film festival. I'm also going to show this at other festivals. Hence, I'm not going to allow you to have the only rights to show it. I'm going to enter into a non-exclusive license. Therefore, I can enter into many deals. You also want to remember that you can exploit it yourself. You might decide, you know what, I think I am best placed to commercialize this. So rather than entering into any type of license or signing, I'm going to commercialize it myself. I'm going to decide where I want to show this, and I'm going to take on the responsibility of the distribution and make sure I am fully in charge of this. Now, when we think about commercialization, we need to think, well, what is it we're trying to achieve? Are we really just there to get the money, in which case we don't want to have to go through all the many other deals that will have to be entered into for commercialization, in which case we do the assignment? Or is it that, you know what, we actually want, yeah, we want to make money. We need to make back the money that was spent on this expensive film. But we want to have some type of say into how this is going to go. We want to make sure that we have some control over the channels that are being used. So usually a license is going to be a preferred method as opposed to an assignment. We should also remember when it comes to licensing that geo-blocking is a thing. So what I mean by geo-blocking is that copyright and intellectual property rights in general are territorial. So your copyright in Trinidad, if you have a contract relating to that, it's not going to necessarily affect your copyright in Barbados because you can divide these territories. Which is why when we look at Netflix, we know that our Netflix catalog is not the same as, for example, the UK Netflix catalog. There are some shows that you can get on the UK Netflix catalog that we don't get here. And that is because the way in which these deals are entered into, they might say, right, we're entering into a deal for you to show Great British Bake Off in the Trinidad catalog, but this show's on TV in the UK. We're not going to let you show it on Netflix in the UK, at least not the current season, because that will detract from our TV viewers. So geo-blocking or geo-dividing is also something you can think about as to how you are dealing in different territories. Of course, we're dealing with a Caribbean region, many different countries, but we're also dealing with the wider world. If we are dealing with different territories, because copyright can differ, different areas, different countries can have different approaches to their law, we do want to make sure that we know something about the copyright in that jurisdiction. As Justin mentioned, this works for hire concept. That is a US concept. Generally, the Caribbean follows the UK development of copyright law. So that concept does not apply here. So you want to make sure, am I actually dealing with things that are relevant in my jurisdiction? If I am dealing with the US, then that concept becomes very relevant. But if I'm not, then I can't be dealing with an area of law that doesn't exist here. Similarly, there will be rules on things like contractors versus employees. All these can differ from country to country. So while generally the Caribbean is going to have a similar approach across the board, you still want to double check, and that will be part of your due diligence. You've had all the information. How do I use this information? And this is where it can get a little more complex, because if you're not accustomed to reading statutes, the written law, you might find it a little difficult, but I do recommend everyone download the Copyright Act of Trinidad and start becoming familiar with the kind of terms you are seeing. Not saying you have to learn the whole thing, it's a very long act, but it's worth to become familiar with the language, because you might be presented with a contract that is using this language, and you might not be in a position at that point to hire legal advice, so you might want to just have a little familiarity with what type of language is being used. Again, it's not that you have to use complex language in a contract, that's not required. And in fact, as Justin said, sometimes deals go wrong because people don't really understand or don't agree on the language being used, so simple is better. But at the same time, if you're being presented with a contract, you want to have an idea of what is actually meant. And you should ask them to clarify as well what they mean to make sure everybody's on the same page. Now, when we talk about commercialization, this is where trademarks come in. So I had mentioned earlier that you might want to get a trademark over the logo or the name of the film. So you can believe that Black Panther would have trademarks for the name Black Panther because that's one of their most successful films. They're not going to let that just be placed on merchandise by anybody. Trademarks, like copyright, also territorial. So if you have a trademark, and when I say trademark, I mean you've gone through your intellectual property office, you filed some paperwork, you've gotten a right to use this name or symbol or name and symbol together in relation to certain goods and services. You got that in Trinidad, it doesn't mean that you got it in Jamaica or Barbados. You will still have to go and file in the different countries. There is now in Trinidad the Madrid Protocol, which means if you file the paperwork here, you can extend that application to different countries, but you still have to go through that process. So you still have to say, right, where am I going to exploit? Because obviously, all these things start adding up. I'm not going to go to all the countries in the world and start filing trademarks because that's going to be very expensive and time-consuming. So where is my target market? Am I going to exploit this in Trinidad, Jamaica, the US, and Japan? Those will be the countries that I want to file my trademarks in. Keep in mind, though, that if there is an existing trademark registered, and it's for similar goods and services that I'm trying to register for, I might not get through, which means I might have to rename this film in a different country because I don't want to be in a situation where I'm trying to commercialize, I'm trying to make my merchandise, and I get sued for trademark infringement. Which is why sometimes countries, or rather companies, have to call themselves different names in different countries. So for example, when Burger King went to Australia, they couldn't operate under that name because Burger King was already registered and operating by a different company. So if somebody's already using that name, it's already registered, you can't then go and use it, which means if you have grand commercialization plans, you may want to do a search very early on at the trademark office, the intellectual property office. For us, it's in Port of Spain. In other countries, it is combined with the company's registrar. Sometimes you want to take all that in consideration because these trademarks are going to be very valuable when you go into merchandising. And this background here has some trademarks that we're all familiar with. We can see the Nike swoosh, we can see Coca-Cola, Google, Wikipedia, Intel. When we look at these things, we already know what we're talking about. A certain value has already been imbued in these words, in these symbols. And it becomes similar for a film. If you see a certain symbol, you know, okay, this is the film this is from. If you see a certain name, if you see a certain character, you know, well, this is where this has come from. And that is the value of trademarks. It protects those so that other people cannot use that name or logo in a confusingly similar way. So it's not that they can't use it at all. There are certain limitations of trademark law, but they wouldn't be able to use it in the way that you are using it. And that is what you're trying to protect, your commercial sphere. So, title of the film, names of key characters, key names in general, key items. Of course, this would be a lot of applications, so most likely you're going to focus on the title of the film to start with, and then you'd go from there depending on how exactly you plan to commercialize. So if you're doing something like a big blockbuster, then you're going to do as many applications as possible. Whereas if you're doing something smaller, you want to think, well, what is my budget? I can't just start filing loads of trademark applications everywhere. I'm going to file for something that I think is very key, and that's going to be the title of your film. That's what you're going to focus on in your commercialization. Okay, so we've done a lot. And I know if you've never heard of copyright and whatnot before, rather you've heard of it, everybody's probably heard of the term, but you don't really know what it is. This is probably a lot to take in one lecture. And in fact, if you have heard of copyright, there's a good chance if you're reading in popular media that this word has been misused because people misuse the words copyright, trademark, patents. They think it's all the same thing. It's actually very different rights, but they'll use it interchangeably. That's a different story. But the point is, copyright is going to be the most important intellectual property right if you're in the film industry. Trademarks become important for the commercialization subsequently when you want to do things like the advertising and merchandising. But copyright is really the heart of your film. So we have lots of different copyright works that come into the final film. We have different exclusive rights on the copyright. We have the fact that we're involving a lot of people. So we saw on the side that directors, producers, the person scoring, the film crew, there's a lot of contracts involved. So all this, anything that needs to be related to copyright, you need to sit down and think what are going to be the elements that are going to be copyright protected from the outset. And that is a fairly in-depth thinking process. Even if you want to sit down and map it out to say, right, I have music, I have photography, I have a scene where there's a mural in the background, somebody has copyright in that. I have this song that this person is creating for me, but I also have this song that is already in existence that I want to use. That's a lot of different things to consider. When you know all those things, however, you then need to see, well, if this is owned by somebody else, I need to seek permission. And I need to seek permission from the right person. Because if I seek permission from the wrong person, there's a chance I'm going to get sued. So when I seek permission from that person, this is where my warranty is going to come in. I need that person to say, you know what, I am the copyright owner. Hand in hand with that, I want the indemnity to say, well, if I get sued, it turns out you're not the copyright owner, you will be covering the legal costs because you have represented to me that you have the authority to enter into this. So this is basically an extra protection after your due diligence. You've done your due diligence, you think this is the right person to contract with. If, however, it turns out that that person has misrepresented something to you, and you did not realize that, you're still contractually protected because you have the warranty. They said they were the person that could enter into this contract. And they also said, well, if you get sued by using their work, they're going to foot the cost of any legal bill. So all levels of extra protection. A lot of contracts involved. So we saw anybody who's touching your film, there's going to need to be a contract. I would recommend a standard non-disclosure agreement for anyone who's going to be involved. That is where you keep anything you learn about the film confidential. If you have something standard, even if you have, for example, the caterers, they're obviously not going to be involved in the copyright aspect, but they are going to be probably seeing parts of the film being filmed and whatnot. Having a standard NDA that anyone who comes onto set cannot disclose what is going on is an easy way to make sure that you're getting a level of protection. You also want to know, what are my commercialization plans? Now, the commercialization plan, again, involves you doing all these things from before and then thinking, well, what do I want to do with this film? And particularly if you are going to have investors, you need to be very clear as to what the relationship between yourself and the investors are going to be. Is it that the investors are going to be paid on a royalty basis, in which case, if the film does not make money, then you are not in a bad position because they are being paid on royalties on any type of net profit made. That obviously is a preferable type of agreement to be in, because if you make a loss, then you'll be not liable for any payments. But if it is that you have to give them some type of upfront payment, then you know that money is going. Or if it is that you're paying on completion or after a certain period of time, then you have that obligation to pay whether or not the film made money. So you need to be very careful. What are you agreeing with this investor? Are you agreeing that you're going to be paid based on the commercial financial success that amounts to profit, and you'll get a percentage of that? That's obviously a safer position to be in than having to pay somebody regardless of the success, because you could find yourself in a bad financial position, and then you have to pay your investors. Now, one thing I want to touch on as well that is something to think about for the future is when you're looking at commercialization and investors, sometimes you might need to take a loan for a project. Let's say you're expanding into a film studio and whatnot. You're going big. You need money. So one source of that is investors. Another source would be to go to financial institutions. Intellectual property is an asset, and it is an asset against which a loan can be secured. So let's say you have a film that has grossed X amount of money. You can take that to get a valuation, and that valuation can go to a bank or some other lending institution to say, this is the value of what I have done. I want to use this to secure a loan. Now, this practice is not very common within the region as yet, and the reason for that is because we don't have a very developed valuation field of experts. Valuation is a very complicated thing. It would not be done by your lawyers. It would be done by people who have serious accounting, financial, and math expertise. The other thing is that it's not something that our lending institutions have really been exposed to that much. But in countries like the US, Japan, Korea, these countries have a greater familiarity with IP as an asset that can be used to secure a loan. Now, this can be something that is really good because your IP is probably going to be your main asset if you are in film. But you need to remember, if you're using it to secure a loan and you fail to pay that loan, that means they can take your work. That is what you're securing. Just like if you fail to pay a mortgage, they can take your house and land, they can also take your film. So while it can be a good thing to think about, you have to be very aware of the consequences and how this is affecting your long-term commercialization strategy, because you don't necessarily want to lose your film if you're not really sure on your ability to pay back this loan. So you want to be very clear with your financials. And usually for financials, you do probably want to seek some type of expertise, financial advice. I think we all know finance is a very complicated field. Distribution, this touches back to what I said on what do you want to do? Do you want to sign and let somebody else decide, right, this is what we're going to do with the film? Do you want to license, an exclusive license to say, right, you can exploit this film in these jurisdictions. I won't be able to do it in these jurisdictions. How long is this license lasting for? Because if we're talking about a license, we're talking about something that is time-bound. Is it 1 year? Is it 5 years? Is it 10 years? Do you instead want to do a non-exclusive license? That would be relevant if you're entering into film festivals. You probably want to enter it into more than one festival, so you don't want to exclusively tie it to one. Do you want a sole license where both you and the other person are able to exploit? Now, Justin mentioned not copying things wholesale from the internet. The reason for this is because you will find a lot of wrong information on the internet, especially when it regards intellectual property. A lot of the contracts on the internet are not good. They don't necessarily make sense. They are very archaically drafted. So you'll see paragraphs without punctuation, and you're trying to figure out what does this mean. That is not good drafting. This is not to say that big professional companies aren't using this type of drafting still, by the way. But big professional companies are paying lawyers on both sides to try to decipher what each side actually means. It's not good practice. It's not something that we encourage. When we teach entertainment law, we say simple drafting. Your client should understand what the contract is about. But do be aware, if you're copying from online, that is probably what you're going to see. That's also probably copyright infringement that you would be committing. But you think, what am I actually reading online, and this is relevant to me? Is the area of law they're talking about even existing in my country? And do the terms actually make sense? So be very wary of things that you're seeing online. Yes, you might want to browse and see, well, what is out there, but you still need to make sure that anything you are drafting makes sense. And if you copy and paste, there's a good chance that it's not necessarily going to make sense. The other thing is, when you're entering into this deal, your final distribution deal, you need to keep in mind that this process is not usually a one-off, here's a contract, you sign it. There's probably going to be a period of back and forth where one side presents the contract. The other side said, I agree to XYZ, I don't agree to ABC. You need to change this. It comes back. And this can be a very lengthy process to really understand what both parties want. It can involve a lot of negotiations, a lot of different drafts until you get the final thing, which means you don't want to be trying to do this and doing all the other things at the same time. So this is why you take it in steps from the beginning. So pre-filming, you're taking certain steps. During the filming, you're taking certain steps. Post-film, certain steps. Because when you get to the step of distribution, you don't want to have to be doing all the steps. You can see there's a lot of steps. There's a lot of things to consider. So you don't want to do all that at the end, because the distribution itself can be a timely deal to work out. The final thing, so you have your distribution. You've entered into your deal. Everything is going well. You then want to enforce your intellectual property rights. The heart of that is going to be your copyright. If you see someone distributing your film without your permission, you didn't enter into any deal with them, you want to make sure you are enforcing it. Now, enforcing it doesn't necessarily mean you are suing somebody every time, but it does mean that you are letting them know of your legal rights and that you do have an intention to enforce this. It could be that you decide, right, you have done this, therefore I will give you a retroactive license for that time period that's already gone for X amount of dollars, because obviously you have to get compensated for that past infringement. If it really comes to it, then yes, you would go to court, but generally people don't want to go to court. That's a very expensive, very time-consuming process. If you have to, yes, you do it, but the other party, if they have sense and get proper advice, probably doesn't want to go down that road, which is why enforcement does not always mean you are jumping into court. It could mean that you are entering into some type of negotiation to rectify the situation. Similarly, for trademarks, it's the same type of thing. You're not always going to rush to court. The good thing about trademarks, though, is that you will have a registration certificate to say, I own this in relation to these goods or services. You have used something similar in a confusing manner. People are going to think that there's a connection here. There is not. You need to stop using this, and you go from there. So when we say enforcement, you need to enforce, because if you're not enforcing, all this work that you did, it comes like nothing, because you've done everything you can do, and then somebody else comes and is taking advantage of you, and you're not pursuing it, because at this point you say, I've done all this, I'm kind of fed up now. But you have to keep going, because you don't want somebody to come infringe the works that you work so hard for to organize everything. So you have to be on it. This sometimes involves things like just keeping an eye on the internet. People might tell you, oh, I saw your film showing here, and you might say, I did not enter into any type of agreement like that. I need to see what is going on. So the enforcement is something you need to do. You can't just stop at distribution, because if you stop there and you then don't go to enforcement, then you can be losing out. And in fact, people could be making money off your hard work. So you do want to make sure that that final step, enforcement of copyright and trademarks, is actually taking place. All right, so we have reached the end of our presentation, so I'll tell Justin if he wants to join me here for any types of questions and comments.
Kwame just now.
I'll start. Make sure your camera's high enough. That's a good day. So I have a lot of questions, but of course, to make time for everybody else, I'm going to say like three things. One, I really love this presentation. I love the coordination between the both of you. And it really changed the way in which I see presentations in general. So thank you for that really professional display of, it was just lovely. Okay, next thing is, this might be, I don't know how this might have my standing in my final in the film program, but this presentation on IP made me realize like there are some things that need to be enforced in some of the courses. Because I remember there was a course where we had to do contracts, and there was the fact that I had a contract where I copy-paste from the internet. Of course, I made some adjustments, but there was some contracts where I was like, works, hard works of work, I can't remember, but I did that, and I got an A in that course. So it was like, I should not have gotten an A in that course in a sense, if we really think about it, you know. Probably get some marks deducted for not having, that kind of way. Maybe I'm being too hard.
I appreciate the honesty, yeah.
Maybe I'm being too hard on the course itself. Huh? But the next thing is I want to ask, and this question is like, I feel like it could possibly benefit everyone in the room as professionals, because as filmmakers, we don't always work doing films. So like me, myself, I work sometimes, I position myself as a full-time storyteller now. So I get called to tell stories for people, whether it be, entities, companies, or people who consider themselves as brands. I help them tell their stories. What I've observed is that in this blog, I was like thinking, is it possible that if a situation where someone is not paying my premium, I can say, yo, you're not paying my premium. Which means if there's any likeness of this video produced after this, because I'm still going to put my best foot forward, that can't happen without me. You understand? Because literally, I saw a project where like my premium wasn't paid. It was for like a relatively big company, right? And because I put my best foot forward, right? Regardless, I'll give the conversation, because there was a negotiation that took place. However, for future video projects that they didn't hire me at all, which is fine, it's fine. But they used a creative direction that would not have been necessarily seen anywhere else. I was exclusive to that particular company, the project, and what they were doing. So I'm thinking like, but this conversation that we're having here today, can I now enforce the fact that, these are the parameters in which I'm creating this without my premium? It cannot be used, my creative direction that I put into this project cannot be used on future projects. Is that possible?
All right, so there are several elements in answering that question. I'll give my view, and I think if Justin wants to add after. Creative direction in itself is not necessarily subject to the copyright protection, because there are certain concepts in creative direction that have to be fixated. In other words, they have to be recorded or put down to have that copyright protection. But even then, it is what is actually on the film, or if you're doing, let's say, a spoken word piece, what is actually being said. The reason for this is because there's a concept in copyright that law students get very tied up with because it's a bit complex, but it's the idea-expression dichotomy. Copyright protects things that are expressed. So if it is written down, if it is recorded, it protects that in itself rather than the overall general concept of what has been written down or what has been recorded. Which is why in that case with the Da Vinci Code, even though the themes were similar, you can't own the theme. So for your purposes, what you would want to do is probably enter into confidentiality agreements in terms of what you are telling them and how they can use that information. That way, if what you are doing, because I suppose I need more information to know exactly what you're doing, but what you are doing, if it is not protected by copyright, let's say it's more of a conceptual thing, then you'd have some type of recourse in terms of the confidentiality of what you have given them in relation to this project. Another thing to remember is that when you're dealing with companies, a lot of the times, I believe at least, there's no formal written agreement. A company might call you and say, I want you to do a spoken word piece for this ad, and then you see that being used somewhere else. That's not what you agreed to, but just because you don't have the written agreement does not mean there's no oral contract. Once you have entered into some type of deal and the consideration has taken place, even if they haven't paid you as yet, the contract is there. which means they can't then go and do something that you didn't allow them to do because you didn't assign that performance. So if we think of wedding photos, right? So when we look on Instagram, we see lots of photographers do wedding photos. They post up people's wedding. Those people in those photos probably have not gotten an assignment of those photographs. Because if they paid for that assignment, which the wedding photographers are very aware of, they would have to pay a few $1,000s extra. That means that the photographers would not be able to put them on their portfolios. So even in things like that, what exactly is the deal you're entering into? So if it is the creative direction, there can be a little issue there as to whether copyright actually extends. Hence, you want to protect your confidential information by setting out the parameters there. If, however, it is something that you are performing in yourself or you are writing a script, so something that has a solid fixation, it's a copyright work, then you have to say, well, what exactly are you agreeing to? Are you agreeing to actually assign this to them? You're probably not agreeing to that because usually that's not, unless you're getting a lot of money, in which case, go for it. But if you're not getting a lot of money, then you probably want to be able to use that to some extent going forward. In which case, just because they pay you once to do a spoken word for this ad doesn't mean they can now put that in another ad. Yep. Yeah.
So in regards to that, I understand
Follow up your question.
All right, so now this is peculiar, but my mind is sparking. You just brought up performances, right? But what if my edit is my performance? If you really think about it, because there's very specific, like.
When you say edit, do you mean actual, you are sitting down doing the editing?
Yeah, the editing. Okay, so I'll explain, right? So in film, there's something, I'm pretty sure you're aware of, it's something called authorship, right? Which is, of course, a director's or whatever gets me unique, nuances that may be easily recognizable by people, right? So personally, like, it's not me trying to toot no horn or nothing, but I don't even need to be credited on works that I do anymore. People just message me. I'm like, hey, come on, like this, like they are aware of what my work looks like. I reached a point where like there's certain kinds of photography where I was like that I do that is not for sale, and like it's not for sale. And I recently did a project where the subject was similar, by the two kinds of photography. One that's very unique to me, that's not for sale because of what it's really for me, and then their mood board and their direction, right? But they like the idea of my photography, but that's not for sale, right? That's my performance, that's my creativity, right? Now, when I say what if my edit is my performance, right? My edit is like, to me, it's very, I would say it comes from my soul in a kind of way, right? Like it comes like comes from my soul. Like it's not to me. It's not a normal thing that happens. Not a normal process. I don't just like I prepare myself. I get into my character. I sit down behind my desk. Nobody could talk to me about nothing, and I pour my soul into this edit. And to me, it's like a dance. The way how I cut, the specific techniques that I've used, that I've been trained to use. Thanks to Lynn over here, right? As part, what if that's my performance? Like, what's that conversation like?
All right, so there's actually a specific case I am thinking of that I think would explain this concept, but Justin is more familiar with the case, the Guinness one with the editing of the ad in a certain style, so I'll hand over to him to explain this.
Yeah, so just a couple of things to touch on. So style. Style is one of the complicated issues under copyright law because it is a form of expression, but is it on the right side of the idea expression dichotomy? Because we could have the concept of style in the abstract as opposed to how it's actually applied in the physical. If it forms part of a physical painting and it manifests in a very tangible way in that sense, if someone copies that, it's potentially infringement. Those cases are the difficult ones that end up in the Supreme Court, or for us will end up in the Privy Council, and we have nothing like that in the region. If you're talking about this in the context of the US or the UK, this is a Supreme Court case waited to happen kind of situation. It happens all the time. There's the Warhol case that the Supreme Court in the US just ruled on, right, where Richard Prince and Andy Warhol involved in their bacchanal about copying photographs and changing them and things like that. So that's legal issues that, for me, are very, very interesting. At a practical level, they're quite difficult to theorize in the abstract. So if you have a particular style that's manifested, that's potentially protectable. Yeah? It just depends on how it's manifested in your work. Is it a form of the expression, or is it an idea behind the expression? The second thing I want to tap onto, I don't know if you've read the works of Friedrich Hegel, but pouring your soul into your works, that's actually one of the philosophical underlyings for why we have copyright protection in the first place. That copyright works are protected because the work of art, the work of music is an embodiment of your soul in that item, and that attaches it to you, and that's why you get a property right in your copyright work. So that's something that is very much a part of the philosophy of copyright. Yeah. So if you haven't read it, check out Friedrich Hegel's work. I feel like that will resonate with you. Yeah. Hegel. Yeah. Right, so the third bit now, in terms of the case that Emma would have mentioned, it's called Nerosian and Arcs, and it was about a Guinness ad that involved a technique called jump cutting, right? So basically, you'd film the whole thing, and then you'd cut out pieces in between and then stitch it back together. So it looks like if the guy is doing one action, but really he's standing here, and then he jumps over there, and it's one fluid movement because you've just removed bits and pieces in between the different actions. That case had two elements. The first case, they said that there was no copyright infringement because all that was copied was the style or the technique of film editing, and that they held was not a copyright protectable work. However, what they did go on to say in Nerosian and Arcs number 2 is that if the work that is being filmed is capable of dramatic performance, meaning you could reproduce the performance, you can get copyright protection in that. So the film is a recording, and that gets copyright. So to infringe that, you have to copy the actual stills or screens or clips from the film directly. Alternatively, you can copy the underlying basis of the film, which is the actual performance that took place in the film. So this is why I'm saying, coming back to the first question, if your style manifests itself tangibly and can be repeated in that way in a performance manner, then it's potentially protectable. But it's a very difficult question, and actually, that's something I'll consider giving my my students as an exam question in future, because that's the kind of interesting areas that are hard copyright. But for me, not hard, but super interesting.
Okay, so you mentioned that case with the cuts not being able to be replicated, right? However, now I hope this is not going to be like staying online, because it's like, if I'm saying here, I don't share with anybody, right? So all of his family, so No, it doesn't stay online? Damn, I can't share this one.
We can talk off air.
I'll talk to you
We'll
after.
talk
yeah.
after. That's fine.
Good Lord. All right, so we do have a couple of questions from persons online in the chat. And one person wanted to know, after the death, because you said 50 years after the death of the author is how long the copyright lasts. So they wanted to know, well, how does it get passed on to family members? How does that how does it work?
All right, so it works just like you would pass on property to any family member, which is ideally you should have a will identifying who this is passing to. If you do not have a will, this is when people start to fight. So just like normal property, if you're dealing with land and somebody dies and there's no will, and this one says this is my land, this one says this is my land, you have about 15 grandchildren all saying it's theirs, it's the same thing. So ideally you should have a will identifying, once you're the owner and you can actually leave it to somebody, identifying who is going to inherit this. Sometimes what people would do to avoid family drama is they might leave it to a charity or something like that. But if you have plans for your family to benefit, you identify who in your family. And the same thing happens in the US, where the right to publicity is a proprietary right. It is an asset. You have to figure out who is going to be able to exploit this after. That needs to be in my will. It has to be in your will because you're dealing with it just like how you deal with actual physical property.
Another question we had is that someone asked if they had a company already, but they wanted to make a sub-brand of that company that offers a completely different service. If they would have to go through the process of registering the company again, or would they just have to copyright the name of the sub-brand?
All right, so a couple of things there. So let's deal with the latter bit first. It wouldn't be copyrighting the name because you don't get copyrighted names. It would be trademarking the name. It would, and the second, well, the initial question is about company law. So when you register a company, you usually have to specify what general industry this company is located in, what it's doing, or what sort of goods and services that it sells are. If the subsidiary is going to be similarly related to that, then it can come under that initial company heading. But just as a matter of company law advice, two things. One, you don't necessarily want to put all your eggs in one basket, because if that one company gets sued, all your assets, all of your finances, etc., then become open to attack in that sense. So if you're having two separate businesses, it's ideal to have multiple companies so that you could limit potential liability in that end. In terms of having companies and having trademarks, when you have a trademark, your trademark does not have to align with your company specifically. So you could have a sub-brand or multiple brands under one company housing, which is unrelated to the initial, primary business of the company in that way. But again, you might want to have your IP housed in a separate company apart from the one that's actually trading. So for filmmakers particularly, you have the film project that is formed to do the film project because of the tax benefits and these kinds of things, but you might actually want to vest the film in a secondary company so that if the film project company gets sued for whatever reason, that the film itself or the trademarks in the film don't get affected.
I also want to say that when you register a company, yes, you have to designate a company name. That's part of the registration process. That is not the same thing as registering a trademark. So just because you have a registered company name, that doesn't mean you have a trademark in that company name. In fact, that's the next step you should take. You get your registered company name, you go file a trademark. Although ideally, you should search the trademark register first to see, is this a good name for my company? Because the company naming process is a lot less stringent than the trademark application process. You can have very similar company names in the same categories. That would not work for trademarks. So ideally, you should check if this is the name I want to use as my branding. I should then see, well, is this something that I could register as a trademark? So having a company name does not equate to having a trademark in that name. That's a separate process you have to go through. It just so happens that in a lot of Caribbean countries, the intellectual property office and the company's registry office are often put together. Here they are not. Company's registry operates separately from the intellectual property office, but even when they're together, it's still separate processes you have to go through for company name registration and trademark registration.
Does anybody have any other questions? Okay, we have more questions online, but let's have it.
Hi, so thanks again for your presentation. I just want to find out a little more about copyright with regards to films. I know in Trinidad and Tobago we have COT, all right? So what organization, if we have any, with respect to film, so if I am a filmmaker and I have to register my film, what advice would you give to us to ensure that our films are copyrighted in Trinidad and Tobago in this context?
Yeah, and this is something that I probably omitted to say at the beginning, which I should have. For copyright, there's no registration requirement. So the minute that you've made your work, it's subject to copyright protection. Unlike trademarks and patents that require registration, there's no registration requirement. So the minute you've made it, once you've written it down, you've recorded it, you've filmed it, whatever the case is, you have protection. So no need to actually go and do anything formal. In the context of the US, you have to register your copyright if you want to be able to litigate on your copyright. But that's a matter of a US specific scenario. So if you're going to exploit your work in the US context, you definitely need to file a copyright registration with the Copyright Office there, and you get a certificate. It's really a formality at the end of the day. If you don't have that registration in the US, you can't enforce your copyright in a court there. So that's a procedural issue. So I know that there is, let's say, COT in Trinidad and Tobago for music. There isn't a collective management organization, to my knowledge, for films. So this is something that you all as film creators could form a collective to actually do collective management for films. That's something that you may want to consider, yeah.
So what do you suggest that we do right now to ensure that your films, I know you just say it's automatically protected, but what steps can you take as a filmmaker?
All right, so this is one of the tricky things about copyright. Since you don't need the registration, it really is a matter of enforcement. So if you have your work, because there's no registration requirement, you don't have to go to an office and say, here is my work. It then really rests on you or anyone else who has a vested interest to see, well, is anybody else using this? Are they infringing my copyright? So unfortunately, it depends how you look at it. Copyright obviously is very advantageous. The fact that you don't have to register makes it a lot easier. It's a lot more accessible than trademarks and patents where you have to go through this whole process. Because you don't have to register, however, despite its accessibility, it also makes it more difficult to police. because you don't actually have documentation that says, I own this copyright. What you would have, however, is your own evidence as to where did you get these ideas from? Did you take the licenses that you need to take from other people? When did you start this project? And what we also need to draw a distinction in is that copyright, as the name suggests, protects against copying as well as other exclusive rights. If, however, something is made independently, so just by coincidence, they make something very similar to yours, but they did not have access to your work, copyright doesn't protect that. Because copyright does not protect novelty. It protects originality, that is the terminology, but that simply means that it hasn't been copied from somebody else. So if person A here makes a film, you make a film that's very similar, y'all did not actually have access with each other, you could not have seen each other's work, you weren't able to, you basically weren't able to say, I've seen this, so therefore I could copy it, then you don't have copyright infringement, despite the fact that it might be very similar. This is why in music copyright cases, when the singers start to give testimony about who they were inspired by, if they were inspired by the person who's suing them, that does not rule in their favor, because then the court said, well, you've obviously listened to their music, and this sounds very similar. So copyright, accessible in the sense that anybody can be a copyright creator. Not anyone can say they own a trademark, not anyone can say they own a patent, because you have to go through processes. Anybody could say they own copyright. Justin owns a copyright in the slides because he did that. He doesn't have to go and register that anyway, so good in that sense. Not so good in the sense that when it comes to policing and enforcing and getting that extra protection, there is really no additional step. So it really is about making sure you are documenting your creative process, you have that evidence impact. So if you go and approach somebody else, you can say, well, you've done something very similar to me. They're going to turn around and say, well, I didn't access your work, but you can say, well, no, this work actually was shown, hey, it was publicly available. If, however, that work has only been sitting down on your computer and nobody has seen it, and it's a big coincidence, then you can't actually protect it in that sense.
I think one key point you are saying there is documenting your process as a filmmaker. It's keeping records and all these things, your creative process. So at least if something comes up, you're protected. You can prove that this concept came from me. Right?
Yeah. And just to add to that, so one thing that's a common misconception in the field is this what we call poor man's copyright. That you've created a copyright work, you put it in an envelope, you send it by registered mail to yourself. That doesn't give you any protection because there's no registration requirement. Two, that doesn't actually prove provenance because I could have copied that work from you and then mail it to myself. So that actually doesn't prove anything that I actually originated that concept or that recording, that song, those lyrics, whatever the case is. So when people say to rely on that, that doesn't actually give you a whole lot of legal protection. Your best bet is to really prove this is the work I created, this is when I created it, which, I mean, I guess the poor man's copyright could, in essence, say, well, at least at this date I would have created it. But from a legal standpoint, it doesn't give you anything extra. In terms of enforcement, make yourself familiar with notice and takedown on YouTube, or on Instagram, on Twitter. I've had this problem where I actually made a video talking about the Juve rum situation with Michael B. Jordan. It got a ton of views on Twitter. Somebody had the audacity to then copy that, include it in a film, and put it on Instagram. Didn't attribute me. I saw it because people were sending it to me. And then I sent a message to the guys, like, well, look, at least attribute me. You didn't ask permission, you didn't do anything, but just, put a link to my page or whatever so that, people could know where it comes from. No response. So then I did a notice and takedown. It took me about 5 minutes to fill it out. And then within an hour, it was off. It was gone. That post was out. And when you get repeated notice and takedown strikes, you get your account suspended. So YouTube has a 3-strike rule. Instagram, Facebook, those I'm not so sure how many, like if there's a strike ruling system. But that's the best way to police online. So you just kind of have to have your eyes and ears out there. The music labels, the movie studios, they have what I call spider crawlers. So these are like artificial intelligence powered software that look for example, for music, they have sonographs and they have the digitization of the musical strains on the stems. So they send this crawler out there looking for it. When they get a match, they have an automatic system to report it. So they automatically fill out the notice and takedown and it comes down. That's why when you put stuff on Instagram, YouTube, etc., you might get a copyright claim later and it's all automatic. So that's, for them it works because they have money and resources to do that. For you, you kind of just have to police it.
So final question is regarding fair use in Trinidad. This is an educational space. Students sometimes, it's not for commercial purposes, it's for educational purposes. Does that apply in Trinidad and Tobago? We've had many instances where COT artists and they troubling some of our students. What do you think regarding that and fair
So
use?
to start, we have no fair use concept in Trinidad. We actually have
Wow.
fair dealing.
Yeah.
Fair use is a very broad, so it's a broad exception that's US specific. The only other country that I am aware of that has fair use in that context is Israel. Several other countries have implemented elements of fair use into their acts, but in the Commonwealth Caribbean, we have fair dealing. So it means that you have to come within these very specific exceptions and limitations. Educational use is one. So the educational use exception in Trinidad will dictate that you could do certain things using a small part of the work, right? Small being in a sense, insubstantial part. So, you're using 2, 3, 4 seconds of a song. If you're using the whole verse, that's going to still be copyright infringement. For teaching purposes, however, you have a lot more leeway. But for educational use at large, for example, you're not going to just get away by saying that this is for educational purposes. For teaching purposes, you get away with a lot more. So the issue that you'd have with CUT is that if you're playing music on campus, you need to get your CUT license because that's a public performance. It's not tied to any educational use. If you're analyzing the music here, from let's say you're training musicologists, you'd get away with that for research and private study. You'd get away with that for criticism and review. You'd get away with that for educational use. You'd get away with that for teaching. But if you're playing music for, background music in your building, you're going to have to get your CUT license. Yeah.
Thank you.
Sure.
All right, you have a question?
I just want to know a little more about how public domain works, in all media, specifically music, but yeah.
Okay, so public domain is a general concept. Yeah.
I guess.
Okay, well, public domain. Okay, when we talk about works in the public domain, there are two interpretations of this. One is very wrong, one is correct. One interpretation, and this is a very common thing, is that if it's out there, you can use it. That is not correct. So when you see things like copyright infringement not intended, that means nothing. You can't take somebody's thing because it's on the internet and say, well, copyright infringement not intended, and that saves you from the law. That doesn't work. Very important, because you like to see those on YouTube videos. Copyright infringement not intended. It's like there's no intention requirement for copyright law. Criminal law, there's certain intention elements, but this is not something we're talking about. We're talking about copyright, no intention. Not knowing about copyright is also not actually defense. But actual public domain works are works that have been made available subject to certain requirements. So it could be that it's put in the public domain under what we call a Creative Commons license. There are different variations of this. It could be, right, I am putting my work online. I will allow anybody to use it, but I'll allow them to use it for non-commercial purposes. Which means if they're using it and generating money, then I didn't allow that. I said you could use this for non-commercial purposes. Could be that I'm putting it online and I'm saying, right, anybody could use this. I'm putting it fully into the public domain, but I, as the copyright owner, giving you consent, this is in the public domain, so anyone who wants to use it can use it, even for commercial purposes. But I might say I want you to say that I am the creator. Or I can just put it out there and say, you do what you want with it, because I, as the person who has the authority, the owner, I'm just allowing it to go into the public domain without any restrictions. So when we talk about public domain, there's a big difference for it being in the public and being allowed to be used by the public. So just something being in the public does not mean you can use it. But often what you will see is what we call a Creative Commons license. So you can check what uses are permitted. And if you're doing a permitted use, it means you probably don't have to contact the person because they will say, right, you can use this, just say that I am the person who created it. So what I recommend you, if you want to learn more about this, read up on Creative Commons, because this is a whole movement that took place many years ago to kind of standardize how works are going into the public domain for usage purposes. Yeah?
There's one additional bit there. So the public domain comprises, well, I guess public domain in inverted commas, Creative Commons works or works that are licensed for open access use like that. So open access, for example, that we all are familiar with, is usually either a standard templated open access license, Creative Commons license, or some variation of that. The other works that are at play would be those that have gone out of copyright, so the copyright has expired. It's those that are the 50 years after the death of the author has passed, or alternatively for its neighboring rights, it's 50 years after the publication or the release of that work. So That's why you could take, for example, old books, like, I don't know, let's say Moby Dick, and make a Moby Dick movie without having permission from, is it Herman Melville? Without getting Herman Melville's or his estate's permission to make that film, because it's in the public domain. Its copyright is no longer, it's expired, yeah.
All right, still have more questions from online. One person wanted to know is there something, what could be done if an arrangement has been made for a paid job and it's very apparent that you will be paid, but after months you still have not been paid, they didn't honor the contract. They would like to know, well, what is the actual recourse, what can they do?
Yeah, so in a situation like that, it's a straightforward breach of contract. What you might want to, and this is where in your contracts you want to be very clear as to when is not just what the payment is and how it's going to be made, but when. When is the payment going to be made? On delivery, 6 weeks after delivery, 2 days before delivery, whatever it is. Again, contract could be anything. You could contract for anything, once it's not illegal, of course. But dictate the terms, yeah? So in that context, it's really just about the breach of contract. You'd have to send them, I guess a pre-action protocol for, if you don't pay me because you breach a contract, that's it.
In those situations, however, while that is the correct legal recourse, you also want to be mindful of whatever relationship you have with the other party. Everybody wants to be paid and they want to be paid on time. But if there is some type of reason that's preventing payment and your fear is not that you won't get paid, it's just a concern of when, then having a basic discussion about, listen, I just need you to tell me when can I expect this payment, I need it by a certain date, is more likely to maintain the relationship than going straight to, I'm going to sue you. So if you want to maintain the relationship, yes, that is what the legal recourse is correct and valid, but sometimes you have to be a little mindful as to, do I want to work with this person again? Because there's a good chance if you say, well, you didn't pay me, I fed up asking for my money, I will sue you if you don't pay me now, that's probably the end of the relationship there. So just a little mindfulness as to what am I trying to achieve here? And to be fair, if they're really not paying you and you say, I'm done with this person because they don't pay on time, then you might want to say, you have breached this contract, you owe me money.
The other question that they wanted to know is if you trademark a brand here in Trinidad and Tobago and the merchandise is going to be distributed worldwide through a seller like Amazon, do you still need to trademark in multiple countries?
Yes, you should. Need to is a strong word in the sense that you are not required to have a trademark to sell products. You need to make sure you're not infringing on anybody else's, but you're not required to have a trademark. The benefit, however, of having a trademark is that if somebody starts using a similar name or logo, you have proof that, look, I have this registered in Trinidad, I have this registered in Barbados, Jamaica, the USA, and this is where I'm selling those goods and services. If you don't have it registered, you have to go through unregistered trademark law if you see something using something similar, and that is a lot more complicated. Unregistered trademark law, usually called passing off, requires that you prove certain elements, and realistically you will have to go to court to get that proven unless the person's going to take your word for it. Whereas if you have a registered trademark, you can say, here's my registration for this country, this country, this country. This is what I've registered for, and you are now infringing by selling similar goods and services. So you don't have to register. It's not some type of requirement for sale, but it is good commercial practice to make sure you are carving out your space in the market.
Okay, no problem. And a couple of students are interested in finding out, is there an entertainment IP law specific class, or is it a certificate that they can take to just get a little more understanding about? Well,
yeah, so we do have entertainment law that we teach at the Faculty of Law. I think this is something that we probably need to discuss with our faculty about allowing non-law students to either take this course or we do some spin-off version of this course that would be tailored to non-law students. I mean, entertainment law that we teach isn't case heavy, it isn't law heavy in that sense, because a lot of it is about, as Emma would have been suggested, social norms. The law says you can do X. Do you actually want to do X is a whole other question. And in the industry, that's not necessarily how things work. When we have our case studies and we bring people in from practice, they give us all the horror stories, but they also give us the realities as to how these things work in the practical sense, where contracts don't exist, where they talk about street justice and village justice for people who, breach the social norms of the industry. The the lack of desire to want to involve any aspect of the law. That when the minute you mention law in our agreement, the other party splits one time and gone, and that's the end of the relationship. So that's something that I think we need to discuss. And then with the whole UWI's move to micro-credentialing, etc., I think that entertainment law is something that we will have to consider offering. Yeah.
What's the name of the course?
Entertainment law?
Just entertainment law. Wow.
Yeah, that's just the name of the course, yeah.
So that's the course that we currently have on offer, but unfortunately, because of the program structure, I believe it is for the law students. Yeah, I know that's what it is right now, but I think it would be worthwhile if we can have a course that's either open to non-law students or maybe designed for non-law students, because we'd have to take in consideration assessment as well. So yes, unfortunately, it is a course on the LLB. I will be teaching it next semester, but we usually co-teach it. But at this point, we don't have another course, but we've got a good response, so maybe this is something we need to look into.
Definitely. It's a undergraduate or a master's?
It's an undergraduate course.
Undergraduate course. All right. Do we have any other questions?
Historically, well, this is actually our second public lecture on international property, because we do one in tandem with our fourth. Yes, because we do some with the IR office at the library, the Alma Jordan Library. So we had those public lectures, and it's still on our Facebook page, so you can go and view it for those online who want to see the other aspects of it. In addition, we know we just came out of a pandemic, but usually for our film marketing and distribution course that is available to our film students, we usually invite a guest lecturer. So Justin and Emma, we will be in contact with you guys next semester, because it's always good to hear these things, to make them aware to our new students. And I encourage both alumnus, staff, and of course, an enthusiast to come and audit these courses. You would not be credited, but it's always good to have access to the information, because it is invaluable as we are currently moving forward in all of our respective careers. Yeah.
And if anyone else from UWI is watching, we do like talking about IP to other faculties, because we do think this is something that people should know about. Intellectual property is an everyday aspect of your life, whether you know it or not, from the phone you are using to your face cream that you're putting on in the morning. So if there's anybody else from other faculties, we are happy to speak about intellectual property, because we genuinely feel that there needs to be more education on this area of law.
So do we have any other questions for Emma or Justin? All right, so if not, we're going to end this particularly interesting session here. So let's thank our speakers for today. All right, it was a great. So as usual, thank you all for joining us within this live session. The video itself will remain online, as well as all the other 3 installments that we had of our series, Filming TNT, hosted by the UWI.Film program. So we thank you guys so much for joining us in the last 4 weeks. These sessions, we really hope that it was interesting and informative. Please, if there's any aspects of cinema or filmmaking within the Caribbean region that you guys would like for us to cover as a workshop or a seminar, or anyone we can invite, please send us an email at uwifilm@gmail.com, or reach out to us on any of our social media platforms. We have this space, we have the time and the resources to bring this information to non-filmmakers and enthusiasts out there, well, non-film students and film enthusiasts, and we are very much dedicated to the continuation of the understanding, knowledge, and learning of cinema in the Caribbean. And before we go, we have 2 other events. So for those of you, well, it's not going to be streamed online. We do have a secret cinema. It happens every Thursday at 1 p.m. here at the UWI.Film studio. We do not tell you beforehand exactly what film is going to be screened. It's a secret. But just note that the film that you will see will be from somewhere, another region in the world that you may not have had access to before. So everyone is invited to our secret cinema sessions. They start at 1 p.m. every Thursday, free and open to the public. And tomorrow, we are also having a screening in collaboration with Africa Film TT and the Cultural Studies Society. This screening will look at a film, and I've completely forgot the name of the film. Letters of Hope, thank you, Letters of Hope from South Africa. And then there will be a question and answer session with the filmmaker following that. Again, it's free and open to the public, and it starts at 6 p.m. here at the UWI.Film program building. So again, thank you very much for joining us, and we hope that this session was informative. And follow us on our social media to keep track of other events that we are doing in the next academic year. Thank you so much.
I love this land too bad, boy. I believe in land. I believe in land.
Hi, I'm Michael Muliga, Director of Green Days by the River and a graduate of UWI St. Augustine Film Program. So check us out.